Thank you so much for being here. My name is Sue Murphy, and I proudly serve as the president of the Robert H. Jackson Center. It's my pleasure to welcome you all here today this morning. 2017 is the Jackson Center's 16th year of promoting liberty under law through the examination of the life and work of U.S. Supreme Court Justice Robert H. Jackson and its relevance to current events and issues. Our work is quite varied. We develop and present educational programs and exhibits for the entire spectrum of ages. We facilitate research, we provide college internship experiences, and much, much more. Through our initiatives, collaborations, and strategic alliances, we touch literally tens of thousands of lives each year, locally, regionally, nationally, and internationally. Overall, we are educators, expanding awareness and informing the dialogues taking place in classrooms, at community and corporate leadership tables, and within institutions of higher learning and public policy in our region, across the nation, and around the world. Much of our programming develops quickly as current events occur and opportunities arise, such as this one today. So I encourage and invite you to join our mailing list and visit our website and Facebook pages regularly to learn about additional programs, news, and information that you will want to know about, participate in, and support. Today's program fits squarely within our mission to engage, educate, and inspire the largest possible audience on issues and challenges facing us all. We are delighted to convene such a dynamic group of experts, practitioners, and educators in this symposium and dialogue on the complexities of immigration, security, and law. This program is made possible through the generosity of our donors and the following funds established at the Chautauqua Region Community Foundation: the Alan Y. Cole Lectureship Endowment Fund, and I'd like to recognize Chuck Cole, representing the family of Alan Cole here today. Thank you very much, Chuck, there he is, for your support. And thank you for being here with us today. Also, another fund at the Chautauqua Region Community Foundation, the Stanley A. Weeks Charitable Legacy Fund, and Libra, and we have a representative here from Libra today as well. There you are. Thank you. And now I'm very pleased to introduce the mastermind behind today's program, John Q. Barrett. He really needs no introduction. John is professor of law at St. John's University and the Jackson Center's Elizabeth S. Lene Fellow, that's a tongue twister, and a member of our board of directors. He's a graduate of Georgetown University and Harvard Law School. In his spare time, John is writing a biography of Justice Jackson, and that publication is eagerly awaited by Jackson fans everywhere. Thank you very much, John, for conceiving of and bringing together this stellar group for today's programs.
Thank you so much, Sue and everyone. These topics are on the front burner, and that's why many constituencies and interested people suggested, asked, inquired what the Jackson Center was doing, and it was already in progress and came together today with the program that I think will educate all of us and be very stimulating. The Jackson Center is devoted to education in the live format, in major events and in conference rooms and conversations, in the internet sense of dissemination, and in the afterlife sense of video and YouTube and so forth. And this program will do all of those things. I want to add my thanks to the Jackson Center staff and board, supporters, and community who have brought this together and make this all possible. I also thank the participants who, as you will see, are not only experts but charming, generous people. As you well know, Jamestown isn't exactly next door to most other places, and with alacrity they said yes, and they came, and they will contribute substantially to our education today. I also wanted to thank three friends who were sort of in the background, but were very important in conceiving, shaping, frankly, recruiting, and getting this program to this moment. Professor Charles Weisselberg of the University of California Law School at Berkeley, Professor Tara Mellish of the University of Buffalo Law School, and attorney Paul Fishman, recently the U.S. Attorney for the District of New Jersey, each an expert, each a would-have been, could-have been, should-have been participant, but their absence doesn't mean that they didn't put a lot of muscle behind us all being here today, and so we're very grateful. My topic to introduce this is the historical piece that jumps off from, of course, this man, Robert H. Jackson, and his perspectives, experience, and a little bit of his judicial legacy in the field of immigration. And so I'm going to talk about 5 topics to set up the panel and the rest of the day. First, I want to talk about Jackson and immigration. And just briefly, Jackson, of course, was a descendant of immigrants, as we all are. Now, Jacksons were the old kind, Scotch and British, and had been in this country since the 18th century. Indeed, one might have made it here in the 17th century before it was this country. But they were just people off the boat, and more dangerous boats than many of the later boats, frankly, and worked and settled and proved themselves and assimilated and became citizens as this nation developed, and down through the generations comes a descendant. Jackson was not someone who thought of himself as the real or true or authentic American in juxtaposition to others who came later. He thought of himself as part of that tableau that we regard as our melting pot and our American ethic. And it was part of his relationships, his contacts, his worlds as he grew up. For instance, Jamestown, his town of law practice for 20 years, his adult hometown, was, of course, settled by lots of later immigrants, including Italian Americans and Swedish Americans. And Jackson was immersed in the fraternal organizations, the personal relationships, the communities that those people comprised. For a Protestant, he was, I think, I can't quite statistically prove this, but quite liberal for his time in crossing the street, if you will, in having networks and friends and relationships in Catholic Italian-American Jamestown and Lutheran Swedish-American Jamestown, and I don't mean to leave out, but immigration is not the appropriate word, small but real African-American Jamestown. Jackson valued people and fair dealing and actual individual relationships with people. And this came out in one place that is relevant. I'll come back to it in a little bit. In the summer of 1951, he was sojourning during his summer recess from the Supreme Court in California. And he stopped at Stanford to visit a former law clerk, Phil Neal, who had become a young law professor at Stanford. And while visiting Phil Neal, Phil said, "Would you like to interview my top student for a possible clerkship?" And Jackson said, "Sure." It was kind of a flyer, and I don't think was very serious at the moment. But he met this young man, and this young man, William Rehnquist, of course, became someone we heard of later. He, in the end, when Jackson had a need, was a resume Jackson had, and actually then got hired and became the law clerk, and then, of course, became a Justice Department official, a Supreme Court Associate Justice, a Supreme Court Justice, and the Chief Justice. And in his visits and lectures and remembrances of that first meeting with Jackson, Chief Justice Rehnquist always said, including here, that it wasn't a discussion about law. It wasn't really an interview. It was really kind of a personality encounter, and what Jackson spent his time telling Rehnquist about was Jamestown and the Swedes of Jamestown, because what he found out from Rehnquist, what kind of name is that it is Swedish, and that Rehnquist's ancestry and the immigrants that brought his forebears to Milwaukee were Swedish Americans. And so Jackson sort of told the immigration history, and I think some tales, about Swedes of Jamestown with great affection, and it kind of transferred to Rehnquist in a way that benefited him. Rehnquist should have remembered that, but we'll return to that. Jackson also, of course, became the Attorney General of the United States in 1940. And during his 18 months in that office, the Immigration and Naturalization Service was transferred from the U.S. Department of Labor to the U.S. Department of Justice. It's interesting to think that immigration was once viewed as just a workforce issue and a labor supply question, and thus it belonged in the Department of Labor in the 1940 period with Europe at war and other concerns. The Justice Department and law enforcement became the better place for it, and it was transferred into the Department of Justice. Jackson, frankly, didn't love this. And at a fundamental level, one of the things that he didn't like about this was it viewed immigrants not as population, as newcomers, as contributors, as workers, but it viewed them as a law enforcement concern. And he's very explicit about this in his private discussions, in his political resistance. He gets rolled by the White House. Francis Perkins gets it out of the Labor Department. Roosevelt puts it in the Justice Department. But Jackson is fundamentally distressed about this sort of labeling or perspective that sees immigration as a law enforcement project. And he had enough real, if you will, law enforcement projects. But immigration became part of what he supervised, and gave him a sense that he really knew this work of the federal government. And that shows up later in his judging. So let me turn to a second topic. This gentleman. This is Alan Cole, father of Charles Cole, who was Justice Jackson's law clerk during 1949-1950, one of two law clerks. And we'll return to that year in a minute. I want to tell you a bit about Alan Cole, who sadly I have not ever met because he passed away young. But through his widow, Gloria, and through his sons, Robert and Charles, and through his work, which leaves a mark, he's somebody that one can get a bead on. Alan Cole was born in Brooklyn in 1922, grew up in New York City, went to Columbia College, graduated in 1942, and was interested in pursuing journalism. And then, of course, Uncle Sam called, so he went into the Army for 2 years during World War II. He was a warrant officer in the Army, served in Patton's 3rd Army Headquarters staff, and in the Occupation Army, spring 1945 forward, in Germany. He was assigned as a staff officer to, yes, Nuremberg. He was part of the Army Message Center and Code Room team, which basically was in charge of setting up the communications apparatus that connected the Nuremberg courthouse to the Army and the American occupation sector which it was in. And once that work was done, he was a soldier with some time on his hands. So what he did was he sat in the Nuremberg trial when he could get a ticket. They weren't available every day, but he had some chances to go into the courtroom. And one of the things that he saw was Robert Jackson cross-examining the first defense witness in the first defendant's case. Hermann Goering, before he took the stand, called a number of witnesses, and Jackson cross-examined them. And they were laceratingly effective cross-examinations. Well, for Alan Cole, that changed his life plans in a lot of ways. He got out of the service, he came to Yale, he became a law student and graduated from Yale Law School in 1949. He then became a special assistant to the U.S. Attorney General, then Tom Clark, and applied for a clerkship to Justice Robert Jackson. Alan Cole's letter to Jackson played the Nuremberg card. It said, I was a college graduate, I was a soldier, I got to be at Nuremberg, I saw your cross-examination, I threw journalism overboard and went to law school. And I've been looking forward to the moment when I could write this letter. I would love to be your law clerk. What I saw at Nuremberg and what I think law can be and do is what I want my life to be about. And the chance to work with you is the dream that I have. Robert Jackson wrote back this letter, which is a little hard to read. But it's a response in the fall of '48, as Alan Cole is a third-year law student, thanking him for his letter. Your references to Nuremberg strike a responsive chord, for, as you have doubtless discovered, those who shared that experience constitute something of a fraternity. And then Jackson says, I'll get around to hiring a law clerk in the spring. And then responding to something that Alan Cole had offered at the end of his letter, Jackson concludes by saying, I do not think letters of reference and recommendation will be of much help to either of us. In other words, I've got what I need to know about you. And soon that became a job offer, and it became the clerkship, and he's there with Jackson 1949-1950. It includes a case called United States versus Knopf, which I'm going to talk about in a moment. Following the clerkship, Alan Cole serves in the military sector of national government during the Korean War as Assistant General Counsel in the Office of Defense Mobilization, and then he goes into private practice in Washington, D.C. Ultimately, his firm, Cole and Groner, was a very well-regarded and successful litigation shop. Alan was a specialist in civil and criminal practice white-collar crime and economic crime is what we would call it. In 1976, he served as chair of the ABA Criminal Justice Section. He was a lawyer's lawyer, much like, of course, the man he clerked for. And you kind of see this imprint passing across the career of Alan Cole. He died in September of 1984 at age 62, and so it was not a long life. Ironically, it was exactly as short as Robert Jackson's life. Gloria Cole, who was married to him for 38 years, is someone who has been a friend and is a lovely person, and she's here with us in spirit today. She's vital in Washington, but this trip was a little much. And her sons, Charles, who are here, and Robert, the older son, who's named for Robert Jackson, are important benefactors and supporters of the Robert Jackson Center. So all of that is to pay a little homage to somebody who's part of the Jackson tableau and somebody who is one of the clerks who Robert Jackson really thought was it. It was a very successful clerkship and a very well-regarded mentee to this mentor. So thank you to the Cole family, Chuck, for this support. Let me now turn to the Supreme Court. This is the Vinson Court circa 1949. You see the Chief Justice in the middle. You see Jackson as an Associate Justice in the back row. He's only 3 up in seniority. This is the rookie justice, if you will, Sherman Minton, Harold Burton, Jackson, Tom Clark. I'm sorry, he's 4th up. It goes back and forth. So Minton, Clark, Burton, Jackson is the rising level of seniority. And then in the front row, Frankfurter, Douglas, Black, Reed, and Chief Justice Vinson. This is the court that Jackson, serving on, and Alan Cole, clerking on, experienced in 1949-1950. This court had a lot of cases that pertained to immigration in various respects. And this is a nice, lucky, out-the-window photo I was able to take a few years ago of Ellis Island. We think of Ellis Island, of course, in the context of immigration and our ancestors who might have passed through there. My grandfather and my grandmother, each side of the family, came to Ellis Island at different points. But this side of Ellis Island is today's tourist site, the museum, the memorial. This is the Wall of Names. It's the story of the American melting pot. And of course, Lady Liberty is not very far offshore on an adjacent island. This side of the island, beginning here and over to this side, is the side of disrepair. It is not accessible to visitors today. The structures are still there, but the money is not currently being spent by the government to rehabilitate them. And what they are the remnants of detention facilities. Because Ellis Island was a gateway and a holding pen. And for some people, the holding pen was the brief look at your papers, stick out your tongue, take your temperature, check your visa, see if you've got somebody who has a place where you can go and live on the Lower East Side or a job or so forth. But other people are held there by the Immigration and Naturalization Service of the U.S. Department of Justice as detainees, both to keep them from coming in, because in this period of time, Ellis Island is not regarded as the United States, which is, and it's close, but it's an interesting legal distinction at that time, not today. And because the outflow, if you will, of people being deported or excluded uses that as a launching pad. One person who I wish to tell you about is Ignaz Mizet. First, the pronunciation of his name is contested, Mizet, I'm not sure. He was of European ancestry, had kind of Hungarian, but kind of Ottoman Empire, Austro-Hungarian Empire ancestry, and bounced around Europe through the Great War, and then got on a tramp steamer and got to New York Harbor, and allegedly jumped overboard in December and swam to shore. I live in New York. That's something I won't attempt. And got on shore and got started as a person in the United States. No legal status, no visa, certainly no citizenship, and he never ever got around to citizenship, which turns out to be a problem. And he made his way to Western New York. He lives in Buffalo. He works as a cabinet maker. He's apparently a, somewhat assimilated, English speaking to some degree, man of his community. He has friends. He has some political interests. He joins some political organizations. He's kind of making a go of it in this country. And he's not bothering anybody, and nobody's bothering him. Decades pass, 25 years. And then Mizey learns that his mother, back in Hungary, is allegedly on her deathbed. So he wants to go see Mama. He leaves the country, which apparently also was an easy departure process, and never quite makes it into Hungary. This is the Cold War and the Iron Curtain, but bounces around Europe for a few years, and then wants to come to what he regards as home, which is Buffalo. So he crosses back and he gets this far. And then he is detained on Ellis Island. He's detained because the Attorney General has information indicating something raises security concerns about him. And to make the story short, he litigates and eventually gets granted a writ of habeas corpus in the district court. It's affirmed by the Second Circuit, and that case goes to the U.S. Supreme Court. The legal issue is whether the government has to give any explanation for holding this person, or whether the say-so conclusory determination based on secret evidence not to be disclosed by the Attorney General is sufficient. And the Supreme Court in Mizey holds 5-4 that the Attorney General has this power. And so Mizey is continued legally a prisoner on Ellis Island. Justice Jackson is one of the 4 dissenters in the Mizey case. And the little quote in the program is a paragraph that you should savor, where Jackson says this country can afford to give reasons. Yes, we have laws, and yes, the laws give power to our immigration authorities, but basic due process means giving a reason or an explanation before this power in this draconian way is used against a person. Mizey was trapped on Ellis Island because he couldn't get a visa to go anyplace else. He was a man without a country. And he was there for quite a while until, frankly, the Cold War climate seems to have broken, and the Attorney General somewhat quietly released him into this country in 1954. And so he did make his way back to Buffalo. He had a wife thereafter and 4 stepchildren and lived in Derby, New York. And after she died in 1969, he sold the home and took the money and went back to Hungary, and not much is known after that, but he apparently died in the 1970s. He was an American, but never a citizen, a person of rights, but not sufficient rights, not to be moved around like the chess piece that the Department of Justice treated him as. Justice Jackson said one more thing I want you to think about. He didn't understand, this is from his Mizey dissent, why the government was afraid to tell Mizey why it was afraid of him. One more case. This occurs during the earlier term, 1949-1950, when Alan Cole was a Jackson law clerk. It concerns a woman named Ellen Knopf, who was a war bride of an American soldier. And after World War II, she was European, German. After World War II, the statute authorized the entry of war brides because guys in the occupation army met and married. This is when fraternization became Frauenization and war brides were a reality. And the Congress responded. And war brides were eligible to come into the country. It was immigration liberality, if you will. Except the Attorney General regarded Ellen Knopf as a security risk. Slim discussions eventually emerged that there was some rumor that she had provided some kind of intelligence assistance to communists in Czechoslovakia. The details of that were never disclosed. She also was held on Ellis Island. And maybe there's a little bit of sexism in here. She became, even more than Mizey, a cause celeb. This is a cartoon of a little figure, Statue of Liberty in sight, standing outside the huge wall with the hand of the Attorney General holding out secret decision to keep her out of the country. Dangerous patterns of the Ellen Knopf case is what the cartoonist captioned it. When her case goes to the court, basically the same issue as Mizey is what the court is considering. And basically the same outcome is the way the case is resolved. The Attorney General has this power and may keep her out. Justice Jackson is one of the dissenters, and I will read you, I'll hold for now. Some of his language is also very powerful, as in Mizey. The government, having won this case, then decides we're going to send her back to Germany. Unlike Mizey, they could send her back because the U.S. military occupation and so forth made an open door in Germany. And the government is doing that in a hurry-up basis. Justice Jackson, whose supervisory responsibilities as circuit justice included the Second Circuit in New York, learns about this on the morning that she's on the plane in New York to be launched out of the United States. And so Justice Jackson stays that deportation. So there's the full court decision, and then there's the individual Jackson decision in May of 1953. Ellen Knopf stayed at the last-minute order of Jackson, and there she is. It's not a detention authority who's grabbing her. This is another picture of her after the happy news, waving from the car that took her back to Ellis Island after her deportation was held up at the last minute. Jackson uses scathing terms in rebuking Justice Department effort to thwart her appeal. Another cartoon. Star Chamber Justice, in other words, our government, the deportation authority, reading Justice Jackson's stay order. And the caption is, "Almost got away with it." In the Knopf case, this is what Jackson wrote. The government tells the court, this is the full case, that not even a court can find out why the girl, forgive him for his sexism, is excluded. But it says we must find that the Congress authorized this treatment of war brides, and even if we cannot get any reason for it, we must say it's legal. Security requires it. Here's the money quote. Security is like liberty, in that many are the crimes committed in its name. The menace to the security of this country, be it as great as it may, from this girl's admission, is as nothing compared to the menace to free institutions inherent in procedures of this pattern. In the name of security, the police state justifies its arbitrary oppressions on evidence that is secret, because security might be prejudiced if it were brought to light in hearings. The plea that evidence of guilt must be secret is abhorrent to free men, because it provides a cloak for the malevolent, the misinformed, the meddlesome, and the corrupt to play the role of undetected and uncorrected. I am sure officials have acted here from a sense of duty, with a full belief in their lawful power, and no doubt upon information, if it stood the test of trial, would justify the order of exclusion. But not even they know whether it could stand this test. And anyway, as I have said before, Ms. A, personal confidence in the officials involved does not excuse a judge from sanctioning a procedure that is dangerously wrong in principle. Robert Jackson was a law enforcement official. He was a national security official. He was a believer in the sovereignty and national security interests of this country. And he was a lawman, which means as a judge interpreting the protections, some constitutional and in this realm more statutory, that require certain showings, certain procedures, certain demonstrations before individuals can be launched about and mistreated willy-nilly. It's something that long before we were talking about immigration, we all know and are familiar with as a strand in Robert Jackson personally. This is Fred Korematsu, a U.S. citizen. So let me be clear, this has nothing to do with immigration. Fred Korematsu, of course, was of Japanese-American ancestry. He was American-born, Nisei. His parents were immigrants, Issei. And the Army orders and the criminal laws backing them up in 1942 put him under a curfew, which Jackson was one of the 9 justices that unanimously upheld, and then excluded him from the West Coast, which is what his case is about, which Jackson is one of the 3 famous dissenters regarding, and then sent him inland to an internment camp for a couple of years during the war until the security threat was believed reduced enough to parole him out. When, by the way, of course, he went to Detroit and worked in American defense production, which shows the lunacy of the broad brush that painted over him. In the Korematsu case, again, a citizen case and a constitutional case, Jackson said this, which is about this thread, which is Korematsu and Knopf and Mizet and other things in Jackson's career. Here is an attempt to make an otherwise innocent act a crime, merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race from which there is no way to resign. The broad brush, call it a religious broad brush, a racial broad brush, a national origin broad brush, that denies individual assessment, is the common issue that runs through these cases, the constitutional and the statutory cases. And Robert Jackson's view was that an American jurist's duty was to ask more from his government than that. Thank you very much. Our morning panel
Didn't know about the Knopf.
will consider national and state powers in the realm of immigration. And I'll do both introductions because then they will just speak one after another. And at the end of their talks, it will be an opportunity for audience questions before lunch. So that's the plan ahead. Lucas Gutentag is a professor at Stanford Law School, also at Yale Law School. He is the founder and has a distinguished career as National Director of the ACLU's Immigrant Rights Project from 1985 to 2011. He served in the Department of Homeland Security as senior counselor to Secretary Jay Johnson, and is really one of the great leading figures in the field of immigration law. As I was canvassing, the first name everybody said was Get Lucas. And luckily it turned out to be easy because he's totally wonderfully cooperative to get Lucas. And the ability to get Lucas, if you will, really made it possible to build the rest of this program. So in addition to the kitchen cabinet I named earlier, Lucas is on that list. Rick Sue is a professor in the neighborhood, the University of Buffalo School of Law, a place that, of course, Robert Jackson was deeply connected to. And Rick Sue is a very productive, attention-getting, interesting, and I think path-breaking scholar in the field of immigration law. And so what they're each going to consider is these powers. I think Lucas is going to set up from the national perspective, and then Rick is going to consider some of the powers from the state and local perspective in the field of immigration. So without further ado, Lucas Gutentag.
Thank you very much. Well, right into the mic, you said, right? Is that okay? All right, thank you very much. It's really a pleasure to be here. And thank you, John. Thank you, Susan. Thank you to the Robert Jackson Center for the opportunity to speak. It's an incredible honor and pleasure for me to participate in this program because the opinions, the language, the career of Robert Jackson have featured prominently in my teaching for the last 30 years. His dissent in the Mazzei case, to which I want to return, is remarkable and continues to be of critical importance today, because the principle that the court adopted in that case, to which he dissented, has never been abandoned. And what he has to say remains an essential question that the court will have to, I believe, grapple with soon. But before teaching full-time, as John mentioned, I served as director of the ACLU Immigrants' Rights Project for a long time, litigating cases on behalf of immigrants and refugees, and to try to enforce, expand, advance the constitutional rights of non-citizens. Those rights have grown significantly over the last 20 years, but they remain in many important respects impoverished compared to what we think of as established constitutional rights. Just as an example, immigrants have no right to appointed counsel in deportation proceedings. If they can't afford a lawyer, they go unrepresented, and the overwhelming majority do not have lawyers when they're subject to deportation proceedings. There's no prohibition on ex post facto laws to make an immigrant deportable based on something that was not illegal when he or she engaged in it. They're subject to long-term detention, months and even years, without any kind of hearing on whether they pose a flight risk or a danger. That issue actually is before the Supreme Court right now, and I was looking this morning to see whether the court was issuing an opinion in that case. They have not yet. They may well do that before the end of the term or have it re-argued next term. Immigrants are subject to summary exclusion if they arrive at the border, notwithstanding the fact that we recognize that it's part of the United States. And even access to federal court review by an immigrant subject to expulsion, even though guaranteed in theory by at least the suspension clause of the Constitution, continues to be contested by the government in many important contexts. So all of these rights continue and need to be developed more fully. But my task today is to take a little bit of a step backwards and to give a thumbnail sketch of some of the legal and historical context in which we're going to discuss the more immediate issues of today in Rick's presentation and in the presentations this afternoon. Of course, controversy over immigration is nothing new. It's as old as the Republic. We all have heard of the famous statement by Benjamin Franklin that the Germans of Pennsylvania would never become citizens, would never learn English, were too insular to become American citizens. And I think that in that respect, it's important to recognize there's always been two strands in our views of immigration. On the one hand, it's absolutely true what the iconic Statue of Liberty represents, open and welcoming towards new immigrants. On the other hand, we've always also had that strand of xenophobia and racism and hostility towards those who are arriving. The first federal immigration laws were not enacted until 1875. And that law prohibited the entry of convicts and prostitutes. But very shortly thereafter, in 1882, I just forgot the critical thing that I always start with, which is, it's a good thing I have the slides, is that I always want to remind myself and everyone, why is it that immigrants should be protected? Why should non-citizens have essential constitutional rights? It's because of the words of the Fifth Amendment and the words of the 14th Amendment that we should always keep in mind. It doesn't say that every citizen is entitled to due process and that every citizen, it says every person is entitled to due process of law. Every person is entitled to equal protection of the law. That's the fundamental guarantee. It's not reserved only to citizens, and there are plenty of places in the Constitution that refer specifically to citizens. The 14th Amendment and the Fifth Amendment do not. They speak in terms of persons. So, returning to the legislation, 1875 had the first federal immigration law, but then shortly thereafter, in 1882, the Chinese Exclusion Act was passed. Literally at the same time that the Statue of Liberty was being built, the Chinese Exclusion Act was enacted. And that was an outgrowth of principally the racism in California towards Chinese, the lynchings, the discrimination, the widespread hostility towards the Chinese in California. But like many things, it permeated Washington as well. And in 1882, Congress passed the Chinese Exclusion Act. And what it did was it prohibited any new Chinese laborers from entering the United States. It deported all those who couldn't prove through the testimony of two white citizens that they were lawfully in the United States. And it prohibited even the return of those who had left with permission and with the promise that they would be allowed to come back. There was nothing subtle about it. The law and the statements in Congress were permeated with racism, and the case ultimately reached the Supreme Court in a case called Chai Chan-ping, or now generally referred to as the Chinese exclusion case. And the issue the court had to decide was the scope and the source of federal government's power to regulate immigration. Chai Chan-ping had been working and living in the United States. He got a certificate of residency. The certificate of residency allowed him to leave, to go home, to see his family, and with that certificate, to return to the United States. He did that. He got the certificate. He left. And between the time that he left and came back, Congress changed the law and said that the certificate is no longer a basis for return. No one can come back who's not already here. That case reached the Supreme Court, and it upheld the power of Congress to enact that legislation. And in words that should be chilling, They weren't then, but they are now. As the court said, if the government of the United States, through its legislative department, considers the presence of foreigners of a different race in this country who will not assimilate to be dangerous to its peace and security, their exclusion is not to be stayed because we're not at war, because we do not have actual hostilities. It was a sweeping affirmation of federal power to exclude, even on the basis of explicitly racial grounds. This was and became the beginning of the so-called plenary power doctrine that gives the federal government virtually unbridled authority to set the substantive category and grounds for who shall be allowed to immigrate and what the grounds of deportation are. It became the foundation of deference by the courts to the political branches. In many respects, of course, the court has moved on. What's remarkable about this case is that it still gets cited today. In the immigration world, we're still mired in this era of Chinese exclusion and the cases that follow. It has never expressly been overturned, and it continues to be cited by the government as the source of its authority. Now, after Chinese exclusion, there were successive other acts that were passed, and this was the era of great migration from the 1890s through the 1920s to the United States, as many of you know. It was also the beginning of, or the time of, a significant shift of immigration from Northern Europe to Eastern and Southern Europe. It was a shift in immigration from principally Protestant immigration, with the exception, of course, of the Irish, who faced enormous hostility when they first came, to Catholic and significantly Jewish immigration of the turn of the century. From lighter-skinned immigrants to darker-skinned immigrants. It was an era when millions upon millions of Italians and Poles especially migrated to the United States. And it generated enormous hostility. The Japanese were not covered by the Chinese Exclusion Act because it was specific to Chinese. The Italians, who were subject to discrimination, the hostility to Catholics, who were characterized as owing their fealty to a foreign religious leader, not to the democracy, and of course, to the hostility against those who were not Christians, Jews, and those who were characterized all collectively as criminal, as lazy, as not potentially good Americans. And just before our conference started, I was handed the original version, or a copy of the original version of that picture that's it. Whoops. Oh, no. That's not. Where's the, is the pointer? In the middle. Oh, thanks. Oh, got it. This, which evidently was done, the work was done by an artist at the Chautauqua area. So there was a lot of agitation for greater restriction. And the first thing that Congress did was enact the so-called Asiatic Barred Zone, which swept far beyond China and all through Asia, still not covering Japan, but all of South Asia, and barring all immigration from that entire area. And then that ultimately led to the infamous National Origins Quota Act, with which many of you are probably familiar. This was law enacted by Congress, openly and explicitly racist, anti-Semitic, anti-Catholic, designed to prohibit the immigration that had been coming since the turn of the century. It was originally set at, as you can see here, at a 3% quota of what the population was in 1910, but then changed and finalized to limit immigration from all countries to 2% of the number of people from that country, of that nationality, who had been in the United States as of 1890. So in 1924, the goal was to preserve the ethnic, religious makeup of the United States as it had existed 30 years earlier, 35 years earlier, before the great wave of Eastern and Southern European migration. And it had stark effects. The number of immigrants from Italy had been in the neighborhood of 150 to 250,000 per year before the Quota Act went into effect. Every year, roughly 200,000, on average 200,000, for the preceding almost 20 years. Similarly, with Poles, there were roughly 2 million Poles who had immigrated to the United States during that preceding period. When the quotas went into effect, Italian immigration, for example, was reduced to 6,000 per year from the almost 250,000 in the preceding years. And Polish immigration was cut to 4,000 a year. And that happened across the board with all countries because, again, it was based on a population of the period before the migration had happened. So that was the Quota Act, and that's what governed American immigration for almost 40 years, more than 40 years, excuse me. Now, during this period, though, during the subsequent period, there were also some positive developments. There was lots of litigation brought by individuals in the United States who were subject to removal. A lot were alleged to be communists, anarchists, other subversives, also individuals alleged to be affiliated with organized crime. And there was litigation about the rights that individuals had as part of the deportation process. And over the period between roughly 1903 through the 1950s, the Supreme Court significantly expanded the procedural rights that individuals subject to deportation had. They didn't question the power of Congress to set the categories, but they said that the process had to comply with fundamental principles of due process under the Fifth Amendment. And the court developed in a series of cases this principle that due process had to be rigorous, that great deal was at stake for someone who was in the United States and being expelled, and so therefore the highest level of scrutiny, at least by the standards of those days, should apply to the fairness of the deportation system. So at that point we had essentially the court operating on two tracks with regard to its scrutiny of the immigration system. On the one hand, the categories that Congress set were virtually immune from review. The procedures that individuals were entitled to in the deportation process were supposed to be subject to very high, demanding procedural scrutiny. And then the Mazzei and the Knopf cases happened. And this was during the height of the Cold War, the early 1950s. First, Ellen Knopf, as John was saying, was denied entry as the bride of a United States citizen based on secret evidence that she was not allowed to see. And then Mazzei was denied return after having lived in Buffalo for 25 years, based also on secret evidence that he could not see. Mazzei, as John was saying, was in particularly dire circumstances because Ellen Knopf could have been, had it not been stopped by Justice Jackson, could have been sent back to Germany. Mazzei had no country that would take him back. Nobody recognized him, and as Justice Jackson said, why should we be surprised that a person that we call a Samson who will tear down our temple or gates is one that other countries should be afraid to take? No one would take Mazzei back. He had no country, and he would be stuck in detention at Ellis Island for the indefinite future. The court decided that case, and against the backdrop of expanded procedural due process rights that it had been announcing in other cases, said Mazzei was different. Said that because he was at Ellis Island, was at the border returning from abroad rather than inside the United States, that he had no procedural rights at all. That the only process he would get is what the government decided he should get, and nothing more. And that was the principle against which Justice Jackson dissented so strongly. And the dissent, not only the language that you've already heard, but the rest of it is compelling, because part of what Justice Jackson does in his dissent is analogize U.S. practices to those of the Nazis that he had cross-examined in Nuremberg and to Soviet law that was the basis for the Cold War. It was a stinging rebuke to what he saw was an abuse of government power. Now, as Jackson scholars know, Justice Jackson had a law clerk during that period who urged him not to dissent and rather to join the majority. That law clerk was William Rehnquist. In a famous memo that became public much later, urges Justice Jackson not to dissent. Of course, he disregarded that. Justice Jackson's dissent has two really important pieces to it, in addition to all of the points that he makes. One is he completely rejects the notion that whether someone's at the border or in the interior should matter for purposes of the fairness of the process and entitlement to procedural due process. But note what he accepts as the governing law of the day, which is that Congress can set the grounds on which a person can be denied entry. Congress has ample power to determine whom we will admit to our shores and by what means we will effectuate its exclusion policy. He's not disagreeing with the power to exclude someone based on their ideology, based on their affiliation, or on other grounds. But he does say there has to be an adequate process to challenge the grounds on which the government says that he fits within a ground of inadmissibility. So that was the governing law, and we were still under the National Origins Quota Act. And then, as part of the great civil rights movement in this country, things began to change. And in particular, in 1965, Congress finally repealed the National Origins Quota Act as part of the same Congress that enacted the great civil rights statutes of the 1960s, the Voting Rights Act, the Employment Anti-Discrimination Act, and so on. In 1965, Congress finally accepted what many had said for decades, that the National Origins Quota Act, grounded in the acceptance of the Discrimination of the Chinese Exclusion Act, had to be repealed. So in 1965, we ended the existing quota system. We apply the same numerical limits to all countries, and the consequence is dramatic. And you can see both the drop-off in the 1920s after the Quota Act was enacted, and then the flat, and then the change that's happened over the course of the last 30-plus years as the 65 Act became fully implemented. And so we've seen a significant increase, especially in Asian and also in Latin American immigration. Now, there is a consequence to the 65 Act as well, and that is that for the first time, limitations were placed on Western Hemisphere immigration. Mexico, for the first time, became subject to numerical limitations as a result of 65 and ultimately the amendments in 1976. So a lot of what we experience with Mexican migration and with undocumented Mexican migration is a result of what happened in 1976 and then the subsequent enforcement at the border, and that broke the cyclical and circular migration that had been happening across our southern border for decades and decades and decades. Both Presidents Ford and President Carter urged that Mexico be treated differently than the rest of the world because of our historic connections and because of the migration patterns. But that has never happened. So what we can see is what's happened with immigration since 1965. We are at an historic high in terms of numbers. We are not, but we are approaching the high in terms of percentage of the U.S. population. The red line is the percentage of the U.S. population that are immigrants. The bars are in absolute numbers. So the numbers back in the turn of the century, in the 1800s, of course, were much, much lower, but they represented a much higher percentage than we have today. And this new wave of immigration, along with lots of other circumstances, I think has led to a whole series of very harsh measures. It started in the 1990s with the 1996 Immigration Act that imposed a great deal of mandatory detention, expansion of detention, made minor criminal convictions retroactively grounds of deportation for long-time legal permanent residents, attempted to deny access to the federal courts to immigrants subject to removal. Now, the Supreme Court has rejected some of those most extreme measures, but importantly, to this day, it has not overturned what the court held in Mazzei. It has distinguished it, it has avoided it, it has not overturned it. Nor has it, and so immigrants arriving at our borders today, whether the southern border in Texas, the ports are ports of entry, those individuals are deemed not to have any procedural due process rights under the Constitution. If Congress chooses to provide them a hearing, they will get one, or they should, but it's not guaranteed by the Constitution, and there's nothing to prohibit Congress from taking it away. And now, of course, we face many of the new issues that we're going to talk about today that raise some of these questions in very contemporary times. The travel ban and whether religious discrimination is permissible, the kind of border enforcement and expulsion that's carried on, whether someone can be denied a hearing, and whether Congress can redefine the border so not only is it where a person arrives, but someone who's been here for only a short period of time should be deemed to still be at the border, whether there's prolonged detention without kind of any hearing is permissible, questions about legal representation, whether there's effective access to the courts, the questions of state and local enforcement and resistance that Rick is going to talk about, and importantly, proposals for new barriers to legal immigration. So I'm going to close with just 2 points. First, as the great constitutional international scholar Louis Henkin said, Chinese exclusion, the case that still is on the books and cited, was decided in the shadow of Dred Scott, in the era of Plessy versus Ferguson, before Brown versus Board of Education, before the emergence of individual rights or international human rights. As he says, I cannot believe that the court would hold today that the Constitution permits either exclusion on racial or religious grounds or deportation of persons lawfully admitted who have resided peacefully here. Well, the question of exclusion on religious grounds, I think we'll get some insights into very soon. The second point I want to make in conclusion is that the questions we face today go far beyond what the courts will decide. Just as the 1924 Act was changed not by an action of the court, but because of the political and social movement of the civil rights movement. The questions today are really political questions that we face as citizens and as members of this society. They go to the very soul of our country. And I believe that there are those in the country and in our current administration who want to return us to the era of the 1920s, who want to use immigration to turn back the clock to use immigration to achieve their vision of a white Christian Northern European nation. I know that sounds harsh, but I think it's what is true. And that's the question that we as citizens ultimately have to confront, is who we are as a nation and what we believe in. How do we continue to preserve the diversity and struggle for the tolerance and the equality that we believe are the essence of America? Immigration has never been an historic artifact that somehow created America and then stopped. It's an ongoing, dynamic process in every generation and in every period. And immigrants change America, and they in turn are changed by America. And the ultimate question to me is that something that we fear or that we celebrate? And I believe it's something we should celebrate. Thank you.
So I'd like to thank John for inviting me to be here to speak to you, and it really is an honor. So we had a good survey of sort of the history of immigration law and how our nation has dealt with it. I want to, however, come from a different perspective, and I'll start with two questions. So why is it that our national debate about immigration so often revolves around what's happening in cities and local communities? On the other hand, why is it that, given that the national debate on immigration so often focuses on cities and local policies, that we are so still intent on marginalizing their role? So let me start with an example. So have you heard there is a current political battle going on right now over the concept and the existence of so-called sanctuary cities? There are many communities that have decided, for a number of reasons, to specify the specific circumstances in which local officials will participate in federal immigration enforcement. Now, as I noted before, the reasons are many. Some are concerned about the use of local resources, some are concerned about police priorities, some are concerned about building political and trust with the community. But what is interesting is that this local policy with regard to immigration has suddenly in some ways become central to how we think about the national immigration debate. If the Republicans are to be believed, you would assume that the biggest single threat to federal immigration enforcement is what is going on with regard to what cities and mayors and police chiefs are doing. And in fact, they're acting on that with that specific idea in mind. The Trump administration has made it a priority to, on the one hand, shame particular cities that they feel have not prioritized federal immigration enforcement, and has gone so far as to threaten to withdraw federal funding from particular communities that they think are refusing to participate in the way that the federal government wants to participate. And it's not just at the federal level. In fact, many states have also hopped on that board as well. Recently, the state of Texas has passed a draconian extensive law that essentially forces local communities and local police departments to participate in immigration enforcement, and in fact heightens the penalties. Local officials themselves can either be fined or removed from office if they refuse to do so with regard to how they govern their particular communities. On the other hand, in some ways, although sanctuary policies are not new, it seems Democrats have just recently discovered local communities as a potential site of resistance in how they set federal immigration policy. There's a lot of talks within the Democratic Party where they're now celebrating local policies on sanctuary as a way of sort of resisting but also reinforcing the priorities that were set up during the Obama administration. Now, although it seems strangely enough that the national immigration debate seems to mirror conflicting sides with regard to how we think about sanctuary policies, there's something surprisingly similar actually about both positions. Although the pro-sanctuary position suggests that we should not have localities involved in immigration enforcement, they primarily look at it with regard to the idea that immigration is a national responsibility and a federal area of law, and therefore localities should not be involved. And although individuals with regard to sanctuary policies who are against sanctuary policies are making a strong effort to force localities to get involved in federal immigration enforcement, they also believe that essentially immigration policies should not be set at the local level. The fact of the matter is, debates about immigration that involve what's going on at the local level has been a part of immigration for a long time. It occurred in 1996, it occurred in 1986, and you could trace it all the way back to the turn of the century. But although this particular local conflict over immigration is not new, there seems to be something that's shared in the sense that we still see it as unprecedented and see it as controversial. Now, I've been thinking about these questions for a long time. But I knew from a very early stage that I thought about it from a slightly different perspective than my peers. Most people who arrived at the issue of local involvement in immigration come from the immigration side. So most of their perspective is shaped by the national and often international perspective that often goes along with how we think about immigration. But I came from the opposite direction. I am myself a student of local government law. I am a firm and committed believer in the power and strength of local democracy. And I also understand how local legal structures affect the American society in which we have our immigration debates. And one thing I realized very early on was that although immigration debates often center on what's happening with the local level, that we never actually take the local role with regard to immigration seriously. But maybe it's time that we do. Now, I do so for a number of reasons. On the one hand, I believe that we think about the current debate about immigration in a broader sense with regard to local power. We could see its connection with regards to lots of things that cities are doing recently and the opposition that they're facing. Their movement with regard to civil rights, for example, Charlotte passing the LGBT ordinance and then getting it shot down by the North Carolina state legislature. Connected with regards to efforts in Birmingham to raise the minimum wage, or Pittsburgh to increase paid family leave. Various efforts to tackle climate change and various controversies with regard to that. On the other hand, I think a local perspective on immigration, to see it from that local level, is also important because we start to break down our particular assumptions about how we imagine immigration policy to be, that it is exclusively a national issue or a federal responsibility. But maybe more important of all, I think it gives us an avenue to reframe how we debate our immigration issue. That instead of thinking that we're trying to debate some imagined sense of what is a national interest, that we recognize that the issue of immigration varies tremendously from various local jurisdictions to other local jurisdictions. Instead of thinking about immigrant assimilation with regard to categories of race or religion or nationality, categories that so often leads us into thinking about the narrative of a clash of civilizations, that we focus on the local level where immigrant assimilation actually exists and happens. And whether or not our local communities offer the kind of social interactions or economic opportunities that allow that assimilation to occur. That instead of thinking about local communities and local officials merely as an administrative arm there to carry out what states and federal government wants them to do, that we imagine them as partners in helping us think about immigration, design immigration policies, but also how an effective enforcement policy can actually be effectuated. In other words, what if instead of thinking about the local level as a convenient site in which we debate national immigration policy, that we think about the local level as, in some ways, what the immigration debates are actually about. Now, I acknowledge that this is actually an unconventional approach and meets up with a lot of problems. And the first of all is, of course, the standard perception that, of course, there is a divide in our country between what is a national issue and what is a local issue, and our firm commitment that immigration is quintessentially a national issue and a federal responsibility. But the truth of the matter, the divide between national and local when it comes to immigration has actually been breaking down for a number of decades. Now, you might assume that it's been breaking down because cities and localities and states as well are suddenly getting involved in immigration, but I want to suggest that it's actually the opposite. It's that federal immigration law over the years has actually steadily expanded beyond what we originally believed to be a federal immigration law. Now, we've heard originally that federal immigration law has a lot of deference with regard to how the courts treat them. But prior to 1986, when he talked about immigration law, it could still be said that it was largely limited to the borders, that it was about admission and removal, and that it was mostly focused on what was happening with regard to Border Patrol or on Ellis Island. But since 1986, we've had a dramatic expansion of federal immigration law into areas that we would consider to be domestic concerns, areas in which local governments and states are concerned about. In 1986, we expanded immigration enforcement to now include employment restrictions, therefore tying federal immigration law to domestic concerns about employment. In 1996, we tremendously expanded the immigration consequences of criminal convictions, essentially tying federal immigration law to now what we consider traditionally to be local law enforcement priorities. And in some other ways, besides these expansion of enforcement, we've changed the way we thought about immigration. If before it was about particular criterias, we started talking about more recently the idea of soft controls, of not whether or not they're allowed to enter or leave, but what kind of lives are they living in the country, and whether or not we could convince them to not come here in the first place or self-deport. But as a result, local issues with regard to education, housing, social service provisions, even land use is now being folded into this idea that they are inherently connected to the immigration debates. Another particular component with regard to this collapse or mixing up of what is national and local in the immigration debates has to do with the history of immigration and the way that we misunderstand it. The fact of the matter is we often talk about the United States as an immigrant country, and that in fact is true. But in some ways it can also be thought about as a country of immigrant cities. The fact of the matter is immigrants have been critical to the urban development of many cities in the country during very many different periods of time. And in fact, some people argue that the revitalization that many cities are seeing today is intrinsically connected to the immigration liberalization in 1965. The fact of the matter is local communities and cities see immigrants and the way that they assimilate them and how they handle that particular issue as crucial to their development going forward. That issue has always been intrinsically important to local officials. But in some ways, we still continue to see it as an exclusive federal issue discussed only in the halls of Congress. Now, what's interesting is the earlier debate I talked about with regard to sanctuary policies mirror some of this mix-up, mirror some of this breaking down of national and local boundaries. The reason why the federal government is so involved and so concerned about what local police officers are doing on the ground now is because they become dependent on local law enforcement officials to carry out federal immigration enforcement. And that's because federal immigration law used to be a very isolated and cabin area of federal law, has now expanded to include the state criminal justice system. We talk a lot about the 6,000 uniformed ICE agents that are responsible for interior enforcement, and President Trump, of course, have also suggested raising that number by another 10,000. But that number pales in comparison to the 35,000 uniformed officers in New York City alone, not to mention the 750,000 uniformed officers within the United States. And the fact of that is, throughout with regard to the Obama administration, the vast majority of removals were with respect to, not the vast majority, about half of the removals were with respect to participation by local law enforcement officials. And there's another component to this. The fact of the matter is the federal government wants to do immigration enforcement on the cheap. If you want to actually do enforcement, and you are concerned about it for a particular reason, then it should be balanced out with regard to the cost of that particular enforcement. But when you try to hoist that particular responsibility onto local officials that you are not reimbursing, that are being paid for by local property tax income, then essentially what they're able to do is expand immigration enforcement capabilities without really addressing the fiscal consequences of it. And of course, for many local communities that have been dealing with unfunded mandates for essentially decades, this is not surprising. On the other hand, you can see that there is a political turn with regard to how we think about this in the sanctuary city debate. At the turn of the century, there were sensational battles between many cities and state legislatures and the nation as a whole. Many cities that had, in some ways, tremendously large immigrant populations early on with regard to the Irish, later on the Italians and the Poles, who then later was able to secure political power at the local level. And it was precisely at the time when that felt that there was a tension between local political power with regard to immigrants and national political power that was resistant to it, that you saw some of the most sensational crackdown on cities. And I think we're seeing that today as well. And in some ways, the partisan fight over immigration mirrors the geographic divide within this country as well. Now, the issue isn't just that the very idea of thinking about immigration has been muddied with regard to whether it's national or local. It's also with regard to the legal tools that we usually use to assess local involvement in immigration, and in some ways how that's inadequate in actually dealing with the issue at hand. And what's very interesting is that the local tools, the legal tools that lawyers often use, though sometimes effective, does not get at the particular issue that we're talking about with regard to whether or not the locality should have a particular role. And as a result, it's leading to all sorts of perverse consequences. Now let me go through what these legal tools are. Now, the traditional legal tools that people have been using to address these issues is, on the one hand, preemption. And the very basic idea of that is that because immigration is a federal issue, that the federal government passes a law on immigration that would preempt any state or local laws on immigration. On the other hand, there is the federalism principle of anti-commandeering. And this what essentially says is that in a system of dual sovereignties, that the federal government cannot force states or localities to carry out a federal objective or that would violate the sovereignties of the states. And we've had a lot of debates about preemption on the one hand and anti-commandeering on the other, especially in the federalism context. What's interesting, however, is when you apply these particular tools to thinking about the particular legal issues that are rising now, it leads to really strange consequences when we think about the plight of cities. So let me start with one. And this has to do with the participation of local law enforcement officials in detecting and enforcing federal immigration law. Now, President Trump has said repeatedly that there is already a federal law that prohibits localities from resisting participation with federal immigration enforcement. What he's referring to is section of the INA that actually, it's called 1373, but interestingly enough, it's drafted in a very interesting way. And the reason why it's drafted in this particular interesting way is because on the one hand, it's trying to affirm that the federal government has preemptive powers over immigration. And on the other hand, the federal government cannot just go out and mandate local enforcement. So how's it written? It's written in this strange manner that essentially says that no local government official can prohibit any other local government official from voluntarily cooperating in federal immigration enforcement. And the reason they wrote it this way is to not go so far as to mandate that local government officials have to participate in immigration enforcement. Now, the anti-commandeering provision of the way that it's written, going against the anti-commandeering law, was actually effective in the early days. It might be surprising now, but one of the first cities to sue this was actually New York City, then under Mayor Giuliani, who challenged this provision, arguing that it was essentially a violation of the federalism principles of the federal government essentially mandating local enforcement. But interestingly enough, the court said that because of the way it was written, it wasn't really a mandate. All it said was that if there is a local official that wanted to voluntarily cooperate with the federal government, no other local government official could prevent it from doing so. Although it gets around the anti-commandeering loop, however, it puts localities in a very strange position, because it essentially says that localities have to tolerate rogue officials, officials that refuse to do the tasks that they are given, refuse to do the tasks that they are been charged with, that they've been hired to do. If a detective or a parking enforcement official decides that instead of doing their task, they want to participate in federal immigration enforcement, this particular law would prevent the city from sanctioning that official on that particular ground. So although it gets around the technical components of commandeering, it actually strikes at the heart of how we think about a locality and a community trying to organize how it allocate its particular local resources. Let me go to another issue, and this has to do with detainers. So you might have been hearing about that recently, right? And of course, there's been a lot of concern about localities not respecting detainers. So detainers, to explain, are essentially requests and notices from the federal government to local law enforcement officials to either hold on to a particular individual that federal immigration officials want to discuss or interrogate, or to alert them about when that particular individual would be released. Now, what's interesting, of course, is because, again, of the anti-commandeering provision, the courts have held that a detainer request is just that, a request. It cannot be a mandate that localities actually have to hold these particular individuals. Now, this provides in some ways a lot of discretion with regard to local communities of whether or not they want to respect a detainer. But of course, this is met up with opposition from the Trump administration, threatening to say that if you do not obey detainers, that you have to risk losing your federal funding. Now, what's interesting about this particular provision that made it a choice as opposed to a mandate is that it also means that if a locality decides to respect a particular detainer, that they're essentially on the line if a mistake was made. And in fact, there was a number of cases that were decided in which the federal government had made a mistake in issuing a detainer that led to a detention of a United States citizen. But because you can't sue the federal government directly, but you can sue local governments, that the courts decided that the local government, though no information on their own on what they acted on, ended up being liable with regard to the detention of the United States citizen. So remember the outsourcing argument I talked about earlier? in some ways wrapped up in the detention and detainer argument is also this outsourcing in terms of who bears the liability with regard to mistakes that were made. The third sort of interesting component with regard to this is one that the traditional tools of preemption and anti-commandeering just does not have a good way of addressing. And that has to do with recent state efforts, I've talked about in Texas, to actually mandate specific enforcement at the local level. And these have taken a number of forms in their proposal, but the SB 4 in Texas actually goes tremendously far. It essentially removes this particular area of policymaking away from local officials, mayors, and police chiefs, and essentially mandates a particular course of action with extreme penalties. And the truth of the matter is, there is very little that local communities can do under the traditional preemption or anti-commandeering line. Because preemption relies on you making an argument that the federal government's interests are being violated here, but that's not explicitly or specifically at issue with regard to a state-local conflict. On the other hand, anti-commandeering has been quite successful, but anti-commandeering for cities relies on them arguing that they are a creature of the state. That does not protect them from the state. And what's interesting here is involved in these particular decisions is a very important question about the relationship between localities and their state, and how much the state can mandate particular action and how much they can enforce particular unfunded mandates on localities. There are important issues with regard to this in thinking about issues like home rule or issues with regard to state legislative preemption. But what's interesting is none of these issues are at play. Because when it comes to immigration, we think about those issues subsumed into the broader immigration debates, and we're not actually paying attention to how we're thinking about local responsibilities and local roles with regard to this particular issue, but also in general. So at this point, I've tried to make the argument to you that there might actually be something important in thinking about immigration from the local level, and that there may be something useful in thinking about localities having a stronger role. I've also said that the reason why this is coming up so often is because of the breakdown between the national and local line and how the federal government is regulating immigration, well beyond the traditional bounds of immigration, but extending well into areas that we would consider traditional domestic law. And I've also tried to make the argument that the traditional tools that we've used, the legal tools that we use to assess these particular issues, are just inadequate in trying to actually get at what is at stake. So if you're convinced by that, then we might leave you in thinking, so what might we do about this? How should we think about this particular issue going forward? Well, the first thing I want to suggest in some ways is that maybe it's time that we think about immigration not purely from a national perspective as a federal issue, but to understand that there is a lot of local concerns with regard to how we think about immigration. And that there may be a realm for us to think about it at the local level with regard to the policies that are made. This, of course, requires in some ways dismantling the very basic idea that immigration is entirely a federal responsibility, but also recognizes the reality that it has not entirely been a national issue for a long time. The second component is with regard to whether or not we think about localities as not just an administrative apparatus for carrying out immigration, but actually a partner. That when we think about immigration enforcement, that we don't think about it as something that localities should just have to obey whatever federal priorities are, but actually maybe an area in which localities can offer substantial advice and substantive information with regard to what kind of enforcement is necessary and what kind of enforcement is effective. That they should be partners and not merely just pawns in this particular area of immigration enforcement. The third particular thing I want to sort of discuss is if we think about immigration from a local level, it's also incumbent upon us to understand that the concerns that we have about immigration is not just in how federal immigration law dictates who could come in and who has to leave. That if we're worried about immigrant assimilation, if we're worried about the impact of immigration, that we also have to turn our eyes with regard to the local issues that are happening on the ground. Do we have the type of economic opportunities available? Are we living in segregated neighborhoods in which the kind of social interactions that we need for assimilation is actually occurring? The truth of the matter, you can't do that entirely from the national perspective. Take the example of France, which, of course, 10 years ago had large riots in their immigrant neighborhoods. What it suggests is that you may have strong national commitments to equality or liberty or fraternity, but if you have segregated neighborhoods on the ground in your major cities, none of those national commitments actually make much of a difference. And maybe at the end, I want to end with an appeal to you. Because the truth of the matter is, the founders set up a system of government that was highly decentralized. They wanted to provide, in some ways, a forum in which strong democracy can occur, that we can have strong debates as people about what kind of policies should happen in our communities, and an avenue to make it happen. And we all do this these days, right? We complain about what's happening in Washington. We complain about their disconnect from what's actually happening on the ground, their misunderstanding of local conditions, and the fact that, in some ways, people don't have a voice because it's dominated by lobbyists. But even though we understand that there is a decentralized system of government and we complain about Washington, the fact of the matter is most of us look to Washington to solve our problems. Well, maybe it's time to change that. Maybe it's time that we have the courage to think about what issues we are facing, to understand that we can, in some ways, through our local democratic institutions, come up with a policy that may actually be effective in addressing it. And maybe have the humility to understand that when other communities come up with certain policy decisions, that those may be deserving of respect. And I say this not only because I think in some ways it will give us an avenue of thinking about immigration from a different perspective, that is one much more connected to what we can do, but also think that it is a foundation in some ways of American democracy. And I hope that we treat it important, as significant as important as it is. Thank you very much.
Thank you, Lucas. Thank you, Rick. That tees up a lot of things, and we will proceed directly to audience questions and conversation. So I will field them, but be succinct and direct your thoughts to the panelists. Sir. There's a microphone being passed down the aisle.
Yes, in the Mercedes decision, in the earlier John King decision, Supreme Court affirmed that Congress has the right to set immigration standards. In the recent Trump attempt, the president has seemed to interfere with that. All right, what grounds did the Trump administration try to affect immigration? Was it for security reasons, and therefore the president has some authority beyond Congress, or was it simply screening procedural considerations?
I'm happy to address that. I think it may be a topic of this afternoon's panel, but let me just say very briefly that President Trump invoked a provision in the immigration statute as the basis for his action. He claimed authority delegated to him by Congress to suspend entry for categories that he is authorized to define, and he defined them as the 6 countries that are included in the ban. The Fourth Circuit Court of Appeals said that it was based on impermissible animus against the Muslim religion. The Ninth Circuit held that he was misreading the statute and that he did not actually have that statutory authority. We'll see how that plays out, and I think we're going to hear from Margot in much greater detail about those points.
In my very first job, I did immigrant visa interviews at the American Consulate in Monterey. And what Mexicans are different and how they come and go from the United States has always been different. The shocking thing I learned in doing it was that the states of California and Texas had their own independent foreign policies towards relationships with Mexico, and would come and negotiate with the Mexican government and would try to, and it was interesting and positive. But some of you will recall when something called Graham-Rudman and budget deficits and taxation issues came to the fore. And all of a sudden, no one wanted to pay for anything. And the federal government came up with budget tricks to do unfunded mandates and to pretend to do things. The state governments pretended to do things and cut their taxes and cut their school systems. And I think we're stuck now. We want security. We don't want to be afraid. We want to be fair. We want to be decent. And yet we don't want to pay taxes. And so how you balance the fear and loathing and the American dream is really hard.
That was more of a comment, but if you would like to build on it.
I'm with Joe Biden. Paying taxes is patriotic. I think we need to pay taxes, and I think we need government services, and I think we need to recognize that we all benefit from the country as a whole, and that that's supported by the taxes that we need to pay. That's another bad idea that came out of California that was then implemented on a national level by President Reagan, in my view. And I think we're paying the price and have been paying the price ever since in terms of our infrastructure, in terms of our educational institutions, in terms of a whole array of issues. It's not really an immigration issue, but I at least share your views.
Yeah, I agree with that as well. And I feel like a lot of it gets put into sort of the political battles about what issue is right or what policy is right. But when you follow the money, you find oftentimes that it's essentially a shuffle game. And what I'm concerned about, as I talked about a little bit, is I feel like in a lot of these political shuffles, that a lot of times cities and local governments are often then holding the bag. The impact is on them that is the greatest. They have very little input in how the policies are specifically made, but all the costs are essentially imposed on them. It's costless when you're making positions at the federal or state level, and I think a lot of the immigration decisions don't take that into account. On the other hand, something that you mentioned was sort of interesting about states, let's say, having their particular foreign policies. And there is, of course, a constitutional concern with regard to the fact that in our nation, under the Constitution, foreign policy should be dictated entirely by the national government. But interestingly enough, and I'll go beyond states, I think that they're in an era of political paralysis and gridlock. Is it right for states and localities to start taking particular positions on things and to negotiate with their counterparts around the world? And of course, I'm thinking about a lot of the city engagement and climate change and economic inequality issues, and they've been talking about immigration as well. On the one hand, maybe that is foreign policy. Of course, it's not the traditional State Department foreign policy. But I don't know if there's an idea if we're getting people together to deal with particular issues. And in some ways, if the Congress is not going to deal with it, maybe this is the alternative.
Yes, question.
It was reported some years ago that the state of Arizona had some draconian laws pertaining to immigration that were drafted by the commercial prison industry. I wonder if you would care to comment on that.
Go ahead.
Yeah, so I've actually done a lot of research on, so it was SB 1070 in Arizona, and it was a big component. And I do think that the commercial prison industry had a role. They certainly do, at least some people are alleging, have a role with regard to some of the Texas legislation going on and many of the prison industry in Texas. But what's interesting, in my opinion, about what's going on with regard to what went on in Arizona is with regard to what interests have sway at different levels of government. So one thing that we thought about with regard to Arizona is that it was essentially a state versus federal government fight, right? Arizona wants to do one thing, the federal government says no. And I think what we don't realize is that actually the person that was behind SB 1070 in Arizona, one of the main person, was Sheriff Arpaio in Maricopa County. And you know, one of the biggest person that Sheriff Arpaio was trying to attack, and of course was one of the resistors against this particular law, was Mayor Gordon of Phoenix. They're in the same county. Phoenix is in Maricopa County. But they had such drastic positions on immigration precisely because any immigration enforcement is going to happen primarily in Phoenix. Again, they're going to suffer the brunt of the cost, right? That actually what ended up happening as a local fight got escalated into what we thought was a national state fight. Because what Mayor Gordon did is because he couldn't get support of the State House, he went directly to the Federal Department of Justice. And what Sheriff Arpaio did once the Federal Department of Justice removed him from 287G agreements was to go directly to the state. So one thing that's important is that there is a lot of influences that you have at the state level with regard to how you enact these policies that may be disconnected from the interest on the ground with regard to what people are actually concerned about. And the prison industry is one of them.
Maybe just to add, if I may, the privatization of prisons and incarceration is a huge issue. The Justice Department, the Obama Justice Department, in the closing months, as you may, I think it was July of 2016, announced, the Deputy Attorney General Sally Yates, who subsequently has become quite famous, announced that the Bureau of Prisons would stop using private detention facilities and use only Federal Bureau of Prisons for federal prisoners. The question then became, should that be the policy across the federal government? And there was enormous resistance to changing or to adopting that with regard to immigration detention because for the Federal Bureau of Prisons, the private detention facilities were roughly 10% of the federal prison population. 90% were in the Bureau of Prisons. With immigration detention, it's exactly the opposite. Roughly 90% are in private detention facilities, and only about 10%, it might be slightly higher, are in federal government facilities. There's been a massive outsourcing of incarceration to private industry for some of the same reasons, namely cost. It's cheaper, which is worse for the detainee. It saves money for the federal government, and then in turn, I think it does create the kinds of political pressures and incentives that you're mentioning, which is more incarceration is more profit for the private prison industry. And this is an issue that is across the board, but it's particularly manifest in the immigration context.
In the Robert H. Jackson Center, I'm curious as to whether Justice Jackson had views on federalism that are pertinent here, and whether, since he served at the end of World War II and later, at a time when immigration was a huge issue, whether he weighed in on some similar questions to the ones we're facing today.
I can speak to his view on individual rights and what he said, and that was what I think John and we talked about a little bit with regard to the question of federalism and allocation of power between the states and the federal government, or localities and states and the federal government. I don't know whether Justice Jackson spoke to those.
I mean, you might.
I would say that he had a nationalist view of immigration, had, of course, been the national top law enforcement officer with responsibility over it, had federalism views that were quite sympathetic to the states as matters of self-government, including in their criminal justice systems. And so that's reflected in some of his habeas corpus, finality views in criminal litigation, civil challenges to criminal litigation. And I'm not aware that he ever tried to sort of harmonize them. So the sort of nationalists of immigration law and the federalists or states' rights person of criminal justice systems and state courts coexisted side by side. And I do see some tensions between the two. Yes?
How might you comment about the recent policy in California to provide legal representation to immigrants in I believe it's deportation proceedings.
New York as well.
Removal proceedings.
Yeah. Do you want to start with that?
Yeah. My personal sentiment is I think it's a good development. I think that in some ways, given the consequences, and there's always been sort of this strange fluke, right? Because we are provided a constitutional right to be represented by attorney, but only in criminal proceedings. And of course, immigration is often defined as a civil proceeding, even though some may argue that the penalties of immigration enforcement is oftentimes more severe than criminal penalties. I also believe that what's going on is that there's just simply a backlog with regard to how the courts are going through all these immigration cases. And having representation not only helps the particular individuals who are affected by these deportation measures, but in some ways also helps the system zero in on the legal issues that are actually involved. So I don't think that's precisely why California is doing so, and of course New York City has also started a similar program as well. But I do think that it may have actually benefits that may be worth considering even for individuals that are interested in immigration enforcement.
I guess I would just add that I think it's the localities, and it's not just California, as Rick mentioned, it's others as well. It's localities stepping into the gap of seeing individuals go through the deportation process, including children. Yeah. When they're arrested at the border and put through deportation proceedings, the children go through the entire deportation process without the right to appointed counsel. A person can have a lawyer if they can afford to hire one, or if there's a pro bono lawyer who will provide the representation. But when that's not available, then individuals go through the entire process without any legal representation. I think states and localities, especially California, New York, others are doing it as well, have tried to step into this breach. The failure of the federal government to provide representation. It could provide the funding, it won't. There's no constitutional right yet, although that issue is being litigated now, whether at least a child should have the right to an appointed counsel at government expense. But the immigration statute specifically says that an immigrant in deportation proceedings has the right to counsel at no expense to the government. And so the federal government is not providing it. The states and localities are stepping in so that the proceedings will be marginally more fair if there's a lawyer present. The studies that have been done show that the participation of a lawyer, to no one's surprise, makes a huge difference in terms of the outcome of the case, the ability to assert legal rights, and so on. So it's an effort to fill that gap. And the backlog in the immigration courts right now is in the neighborhood of roughly, last time I looked, was I think up to 500,000 cases backlog. So people just sitting, they're not in detention for the most part, but people just sitting waiting to have their cases adjudicated.
Yes, Miss Middle. Her first with the microphone, and then back to you.
So reading immigration decisions from past decades, the most frustrating thing is always when the courts just point to the plenary power doctrine and say, this isn't in our wheelhouse, we can't do anything, hands off. And I've been very heartened by the decisions lately coming from the travel ban and the recent Sessions v. Morales-Santana that of course struck down the gender decision with passing on citizenship. And I'm wondering, in your opinion, is this a product of the current political climate, or is this possibly an indication that the plenary power doctrine is on its way out?
Do you want to say something? I'm happy to speak to that.
You can speak for it. I have something to say.
We can hope. So as I said, and as I tried to indicate, there's been some, marginal erosion, but not a rejection of the plenary power doctrine. The case you mentioned, the Morales-Santana, was a case of gender discrimination in the acquisition of citizenship, not with regard to naturalization, but whether someone born outside the United States is a U.S. citizen by virtue of their parent being a United States citizen. And the question was whether it's permissible to have differential treatment if the child, these were non-marital, so-called illegitimate children, if the father was a U.S. citizen versus the mother was a U.S. citizen, whether it's permissible to treat them differently based on the gender of the parent. And the Supreme Court essentially said no, although it said we don't know how to fix the problem, but we know that it's not permissible to discriminate. So that was followed up on some earlier cases. The courts have found that there's some greater protections for people at the border if they are a previous legal permanent resident, or if they're a legal permanent resident returning. The court, in a case that I argued, held that the habeas corpus guarantees the right to access to federal courts if a person's subject to removal. They've cut back some on the detention power of the federal government and found limits there implicit in the Constitution, but not necessarily there if Congress wants to legislate explicitly. So there's been all this work around the edges. Whether something like the travel ban will be an opportunity for the court to directly confront the question of whether religious or racial discrimination could be permissible if Congress actually enacted that. I think it's more likely that the court will say, we don't think that's what's going on. But if it were, then it would be impermissible, but we're not actually going to say something along those lines. So I think we're still in the battlefield of trying to have the plenary power doctrine be trimmed back and gradually hope ultimately to what I would call normalize immigration law. There's no reason why the federal immigration power can't be both robust with regard to protecting national security and enforcing the border and protect individual rights the same way that the federal government can act in every other realm. We recognize that there are competing interests. There's individual rights, there's national interests, sometimes those are in conflict, and the federal government's responsible for reconciling both, and the courts are there to ensure that the Bill of Rights applies equally in all those settings. And that's what Professor Henkin and others have argued for a long time. We can normalize the federal immigration power, protect the national security, but consistent with the same principles of individual rights that apply in every other context. And that's what we're striving for, but we're a long ways from getting there.
So I just want to add a little bit. I mean, it's great. So one thing I would say, one argument, a question he asked is, are we just in a political moment? And in some ways it's interesting because the foundation of the plenary power is always in political moments. It's almost hard to think about the plenary power as a free existing doctrine because every case that came up to establish it happened at a time that was perceived as being extraordinary and politically an outlier, whether it was the yellow peril with Chinese exclusion or concerns about communism or anarchy and during the Cold War. So in some ways, that is how we address the plenary power in immigration, and that may be the reason why it's never really been normalized, because it's always been seen as an emergency provision. So are we in that same moment today? Maybe, but in some ways it wouldn't be an outlier. The second thing I want to mention in some ways that might be interesting is I think to the extent that maybe plenary power might show signs of erosion also has to do with how we're starting to think about standing. So a lot of the early cases imagine that when we're dealing with immigration, we're just concerned about the rights of the individual seeking entry. But a lot of these recent cases and a lot of litigation surrounding a lot of the executive orders are now really taking into account the fact that there is a father or a mother that is interested in bringing a child over. That there are particular states or communities that are interested in having particular immigrants come work in their university system. And those, in some ways, is a recognition that when we're dealing with immigration, it's not just their rights, and those are important, but in some ways implicating the rights of all American citizens and many American institutions. And I think courts are just starting to take that seriously, and that may also be leading to some of the erosion that we're seeing now.
Do you have any opinions or predictions about the future of the Deferred Action for Childhood Arrivals program?
I'm hesitant to make predictions. I have opinions. I mean, I think it's very significant that the Trump administration, well, everybody's familiar with the so-called Dreamer program that gives deferred action to young people who arrived before they were 18, who've lived basically their whole life in the United States, and who under President Obama in 2012 were given a mechanism by which they could get the so-called deferred action, which allows them to be here in a kind of quasi-lawful status and to get have work authorization, and in most states now by state and local law to qualify for in-state tuition, to basically normalize and come out of the shadows and work with permission. There's roughly in the neighborhood now of 800,000 students who have, young people who have registered for that and gotten this status. It has to be renewed every 2 years. President Obama tried to expand it. That was enjoined by the courts. But President Trump repeatedly has said that he doesn't want to get rid of it, but he says it in ways that are always kind of slightly ambiguous. Or at least then subsequently contradicted by something else he says, which is not unique to this field. And so I think it's a little bit murky, but so far I think that the power of that movement, the fairness of the program, the kind of claim of the individuals, the benefit to society, all of that I think is causing the current administration to hesitate to end it. But I don't think it's rock solid either. It seems to be an internal debate within the administration to a certain extent.
I think it's impossible to predict because the way that they're using it is to make it impossible to predict. And I think that's actually the saddest part about it, is that I believe that what is going on is that this group of individuals is being used as political football, and in some ways for the next round of potential immigration discussions or reforms. But we're keeping essentially a group of individuals in a limbo state. Neither completely undocumented, neither completely legal. And in some ways, because they're sympathetic, unfortunately, seems to be the reason why it becomes, I believe in many people's mind, that it'd be an effective political leverage point.
Yes, Joyce.
Recently, I lived part-time in Chicago, and Mayor Emanuel has been, has stated publicly that Chicago is a refuge city. And a few weeks ago, there was something that hit, I think, national news, because there was a father who had come into the country from Mexico some 20 or 25 years ago. And he was, gainfully employed, paid taxes, so on and so forth. He was stopped for I believe, a traffic violation. And of course, there was a indication that he would be deported. He's married, has 2 sons who are born in this country, so legally. President Trump has indicated, to Mayor Emanuel of Chicago, that should he continue to carry on his support of Chicago being a refuge city, that, as you say, federal funds may stop. Is there any example of this actually taking place?
So with regard to the threat of withdrawing federal funding, there is a longer debate about whether or not the federal government can actually compel states or localities to do certain policies by dangling purse strings. There are also, on the other hand, many cases about if the consequences are too large, that would itself be problematic. But let's put that aside. I think what's sort of interesting about this discussion is that in some ways, we have seen it as being appropriate for the federal government to essentially take this particular issue and never really listening to why Chicago is doing what they're doing, right? No one's really talking about why Rahm Emanuel, if they say they want to be a refuge city, why that's important to Chicago to be a refuge city. Why do the residents of Chicago want to have this particular happen? It just becomes sort of this battle between 2 big figures and this particular concern about what kind of leverage I can exert against you, right? It's all punitive. And I believe that's what's missing. Because if, for example, this individual was picked up by federal immigration enforcement officials, or if he's actually being detected by a local law enforcement official, right? What it shows is that all this discussion about policy at higher levels may not actually be trickling down to what's happening on the ground. And the truth is, we're probably at a stage where, given all the concerns about policing and law enforcement in other contexts, that we probably want more policies and more professionalization than to just let things happen. And this particular battle at the higher level, without taking into the concerns about what cities want to do, what police chiefs want to do, seems to be taking that off of the equation. And I think that's another point for concern.
We have time for one more question. Okay, I held back one card, so let me share the Ellen Knopf, the rest of the story. Because after the 1949-50 United States versus Knopf, Jackson, law clerk Alan Cole term of the court, she was still, in the view of the Attorney General, somebody who didn't belong in this country, and that had been upheld. So she languished, she was paroled out a little bit, but she mostly languished in Ellis Island for an additional period. And she became a cause celeb. This might have been sort of a gendered, subordinate view of a woman working in her favor. She was a war bride, but members of Congress took up her cause. Media took up her cause, lots of publicity, movement towards a private bill, a law that would make her an admitted U.S. citizen. And eventually, the Attorney General, in the face of all that, folded and paroled her into the country, where she then was the wife of the American soldier and lived a quiet, anonymous life, but wrote a book, The Ellen Knopf Story. They're hard to get, but not impossible if you surf around on used book sites. And it's a great story. And as the book was nearing publication, she was drafting, I'm sure there was a ghostwriter, but she was drafting her acknowledgments, which began to Kurt, her husband, whom I love. But she decided she should check before she named other people. So she wrote Robert Jackson. And she said, here's a draft of my book acknowledgments, which lists my husband and my lawyers and the judges in various courts who understood and took my side in this argument. Is it okay if I acknowledge you? And I'm sure Jackson was always fast about turning around his correspondence, seemed to have hesitated a day or two to think about, responding to a litigant, but her case was over. But this was kind of a weird request, but she was Ellen Knopf, who he had been quite sympathetic towards. He writes back a really quite direct and businesslike letter. Dear Mrs. Knopf, and he basically says, I really don't think it's a matter on which I need to have an opinion. You're free to acknowledge in your book whom you wish to acknowledge, but I actually don't really think I deserve any special acknowledgement because I was just doing my job.